Good morning, afternoon, or evening. Welcome to All Things Social Security. I am Stephanie Joy, the attorney at Joy Disability. Welcome to the channel, and I hope you enjoy the video. Have a great day. Bye-bye. Good morning, afternoon, or evening. Stephanie Joy with All Things Social Security and the law practice of Joy Disability. I wanted to run over with you guys about a case that came out recently in the 11th Circuit, and it's got some reminders that I think it's really important that people understand. It's some hard truths, of course, in the Social Security disability law area. And so I'm just going to go through my notes about what I think you need to know about this one. Let's say it's pain. If you go into your doctor's office and you say you have your pain is like 10 out of 10, that is almost an insurmountable statement. It just killed the credibility because you drove to the doctor's office, you walked into the doctor's office, you sat in the waiting room for 15 minutes, you signed in, you maybe even paid your copay, and you're saying you have a 10 out of 10 pain. Most of us consider what a 10, 9, 8, there would be no driving. There would be barely any speaking coherently. And I know if I was in 10 out of 10, I would be in the ER. I'd probably be in the ER for an 8. And I'm not even sure what that means. The only thing I can relate it to is when my gallbladder decided to rebel and nearly explode and all that business about 18 months ago. And that was really severe pain. And I've, had labor before, so I know what severe pain is. Yeah, the 10 out of 10 is a bad one. I'd say 9 out of 10 is a bad one, meaning it doesn't sound credible for most people. Talking about a migraine when you're able to drive to the office means that you might be inflating the terminology and it's really more akin to a headache. Just things to think about, guys, the way you're going to word things when you have a case to your doctors, because they put it in the way you say it sometimes, oftentimes, particularly if it's harmful. Don't ask me why. All those good things you told them that were helpful to your case and didn't make it in, but those things did. So you have to be accurate, you have to be thorough, and you have to be consistent. If something is really happening and it's affecting your ability to function, it needs to show up in the record, and you want it to happen with regularity over the course of time. It doesn't have to be every month on the dot, but you know what I mean? Over the course of time. So it's not like something that was a snapshot day, a bad day, and never to be seen again. This fellow in this particular case also had low testosterone and fatigue. I think I mentioned that before. He had argued that the ALJ failed to properly account for these problems. When he determined his RFC, the residual functional capacity, as you probably know, the RFC is the judge's assessment of what a person can still do despite his or her impairments. And this is where many claimants' cases are won or lost. That is definitely true. Just as an aside, you're going to win under a listing or you're going to win under RFC, basically. Lots of claimants think that proving a diagnosis should be enough. It's not. It's not even close. I have a whole video on that. It's probably a little dated. I should probably update it. But it's usually a diagnosis short of like a compassionate listing is not going to be enough. Social Security is definitely heavily in tune with function. And that's because the whole question isn't whether you have a diagnosis or an impairment. Most of us do. It's, can you work? So what is that residual functional capacity you still have left to do a simple job, a sedentary job, How long can you sit? How long can you stand? How much can you lift? Can you use your hands frequently or next to never? Can you use them constantly? Can you stay on task? Can you keep attendance? Stick to a schedule? And can you sustain those kind of work activities day after day, week after week on a sustained basis for like at least 6 months, I'd say. So even if your fatigue is really real, the legal question becomes whether the evidence shows work-related limitations stem from that fatigue or the pain or the other things as well. In this case, the court had noted that the ALJ acknowledged that the claimant's complaints about low testosterone and fatigue, so he acknowledged them, and he did cite records addressing the condition, and that was enough for the court because the judge, in his own decision, pretty much prove that he considered the condition, considered the records that discuss the condition when he incorporated that into the person's ability to stay in work. So as you can see, it's like he didn't have to overanalyze the fatigue and the low testosterone. He didn't have to make a whole book on it. He considered the issue. He just, he did it in writing in his decision, which is obviously the only place where it counts. And so his residual functional capacity analysis held muster for his decision. So important, guys. And like I said before, many claimants in general argue that the judge ignored an important problem that they perceive as important. And if that's true, that is an appealable issue. But if the written decision shows that the judge at least recognized the issue and mentioned supporting records, then that's going to be harder to overcome on appeal. So if you've been denied, when you look at your denial, look at all the impairments you alleged in your application or new ones on your appeal or ones you later got submitted to the SSA that came up in the interim. And that could be found in medical records or that you've actually sent them a letter about or called them about, or, like put it in one of those hard stop points of a case, application, appeal. And if you don't see, and it's in the medical records, make sure you know exactly where, and you don't see him mentioning it at all, that could be definitely an appealable issue. Or if he mentions it but doesn't discuss any records that actually exist, that could be an appealable issue. So try to break it down in a few lessons to take home. To sum it up, having multiple health problems does not automatically equal disability under the Social Security rules. You may have spinal problems. You may have fibromyalgia, fatigue, depression, medication side effects, low testosterone. But if the judge thinks that the evidence does not prove disabling functional limits, not just functional limits. Like in this case, he acknowledged the person had significant functional limits, but it wasn't limiting enough to eliminate all jobs because he could do a limited range of light work on a sustained basis. Second lesson, guys, consistency matters. The medical records don't have to be perfect, like I was saying, and they're not going to be, because life is just not that perfect, and neither is the medical profession. But symptoms do fluctuate. There's good days and there are bad days. But when the records are repeatedly inconsistent on a major issue like pain, severity, fatigue, side effects, your daily functioning, there's a good chance it's going to be used against you because it's what it says. So you got to make sure that you do your part to make sure that those complaints are heard by your doctors, that you're having them follow you for them. Just saying it out the side of your mouth because you're not a complaining type isn't helpful. And a lot of you aren't complaining types. You were working even in pain until you couldn't. So, you just got to start to be, I always say to people, be that squeaky wheel you never were. Again, diagnosis is not going to be enough. The key question isn't just what you have, whether your condition or conditions prevent you from doing work in a setting on a sustained basis. And then, the big one here too is appeals are very limited. They're not rehashing your case. They're not letting you usually get in any more evidence. A lot of people think that if they lose before the ALJ, the federal court will step in and fix everything. That can happen, but it's very rare to have a complete reversal. And it's definitely not going to be unless there's an appealable issue. And then usually it's a remand. Give the judge a second shot at writing and correcting the things he didn't do, which means he could go ahead and deny you anyway. Although I find them to be very good about second time around. So again, because the federal district court is usually deciding whether the ALJ's decision had enough support to stand, because that is the law. That is its jurisdiction, so to speak. The standard of review. Did the judge's decision have enough support to hold up his decision? It's a legal question. It's not whether they think they would have made a different decision. It's such a different process. Yeah, and as a takeaway, and this might most be the most important thing about this case, I think, the best time to build your case is way before your hearing, way before you get a denial, and certainly not after you get a denial. That your opportunities on, well, it could be before you apply, maybe you've stopped working. You could start building evidence then. You're still going to assert that you became disabled the day you stopped, probably, but you don't have to file right away. You can start building your evidence, start going to those doctors, get that schedule ingrained of going to the specialist and following up on everything. Initial and recon, same idea. I am the nag hag with my clients. Some of them are appreciative. Some probably want me to shut up, but it's because I want them to win as soon as they can. I don't want them to have to go to a hearing at all if we can help it. So doing more on initial and recon, and like I said, even for a few months after you stopped working, can be really key to building that evidence so that you're not scrambling, you're not at a hearing with all of these issues where they're not consistently in the medical record, and it can shoot your case like this fellow. Your treatment records matter. They are so important. Your symptom reporting matters. Your consistency in doing so matters, and the consistency of your providers to make sure they're in there. And because that's a wild card for you, that's why I talk about message them. Not every day. Maybe like in between each appointment once, And then when you're at your appointment, it could be like an interim, and every case can be different, so don't take this to heart. Let's say you only see your doctor every 6 months, which for a severe impairment, I don't think that's enough when you're trying to win a case, but generally speaking. Oh, there's a tortoise under my feet. Maybe you see him, have your visit with him. Maybe at the visit, if they have you fill something out with all your symptoms, that's a great time. Just be careful and take your time with doing it. If they don't do that, sometimes they have it in the portal beforehand, like you can register online, do it the night before, whatever. If not, I would probably fax something in the day before and say, this is for Dr. So-and-so. I'm seeing him tomorrow and he needs to know this information. I want it in my file. Hint, hint. So that's at the time of your visit, one way or another. But you're going to go 6 months in between. What about doing that at 3 months? And I'm just giving examples here of how to be proactive with your doctors. Particularly, I mean, when you've had an exacerbation, I think they should know that anyway. But I think maybe 3 months is not a bad idea if you have ongoing symptoms, even if they're not exacerbated. Just to be reminded that these are still going on, doc. I have an appointment in about 3 months. We can talk about it then. So I'm not necessarily saying, you must change your schedule, but this gets stuff in there in the interim. It's going to have a different date on it. It's going to have something 3 months before. Otherwise, you're going to have these 6-month gaps. I digress, but these things I get reminded of as I'm going through this case law with you. Yeah, and the way your limitations are documented is going to matter. And the way your doctors describe your functioning also matters. And of course, part of that is a wild card. Some doctors don't report squat. Some are much better. Sometimes it's a medical assistant. Some are good, some are not good. It's like anything else. So the hearing is not just about telling your story. It's about whether the documentary record supports the story that you're going to be telling the judge at the hearing in a way that Social Security and the judge is going to recognize as legally significant. I just want to be really clear here, guys. This particular case, the lesson here is not that claimants cannot win, because people win on those things all the time when they have robust enough, consistent enough evidence. You absolutely can. And like I said, many do. So it's not that pain doesn't matter. It's very important. Or that fatigue doesn't matter. That is super important too. Fatigue, like I said, get a specialist for that fatigue. If you want a little boost in your evidence, that and side effects all matter. But it's that they have to be documented very clearly, consistently, in a way that will show when it's like extrapolated to the work environment, why you would not be able to successfully hold down an 8-hour day, 5-day-a-week job. So report everything, report your medication side effects, the fatigue, the pain that can affect sitting, standing, walking. Sometimes pain affects concentration. It can affect hand use. Pain can also affect how you treat other people on the job. It probably affects you at home. We can get irritable. We can get, short-tempered with people when we're not feeling well. All that stuff can be explained to your doctors, and not just once, but over and over and over again. Your case might be a year, 2, 3. You just don't know. Symptoms also are known to vary, and if they do, you should just say that. because fluctuation is definitely a real thing. So it's not that you have to say the same thing, and you shouldn't if it's not the same every week, month, or 3 months. It's the bigger picture that's going to show. It's going to be the kind of the consistency, as variable as it is, over the course of time. So remember, when you're in federal court, and this is why the fellow lost at the 11th Circuit, the question isn't, could this claimant have been found disabled? Of course he could have. The actual question under the law is, did the ALJ give enough of an explanation, back it by enough evidence to survive our review? And that's what they're looking at. It's a steep hill. It's a really steep hill for claimants to overcome a denial like that. Build your record, guys. Build your medical record. I think I'm beating it to death, right? Consistency, accuracy, repeatability, if it's a repeated thing. Because remember, a one-hit wonder snapshot of a bad day is not going to win your case. So if you have lost, obviously, if an appeal is the right thing to do, depending on your case situation, do it. But it's not going to be a do-over. You're going to appeal to the appeals council. That's not a do-over. You're not going to get to have a whole new shot at the ball to get the appeals council to flip it. They're going to look at what's already taken place that the judge had, and the FTC is going to do the same. There are limited courts of review, and they have a lot of differential requirements to the ALJ decision. All right. Take heed, guys. You can make your case stronger if you're having troubles with it. You just have to really be diligent. I always say to my people, it's not your full-time job, but it is your priority job. It's not going to be 40 hours a week you have to go for treatment, and follow-ups, but you have to, you do it pretty regularly when you're trying to win the case. It'll get less later, when you're preserving your benefits through CDRs. Much easier, much easier. Anyway, so that's that wonderful 11th Court Circuit case. Just try to drill home the points that you can take from it to make your case better, particularly if it's any of the things that this fellow had, but it applies to, overall, it applies to, every kind of impairment. I would say, yeah, certainly those. And I feel like it's particularly important when you're a younger person, meaning 49 and younger. It's a high mountain to climb, guys. All right, I'm going to take off.